Good morning, everyone, or I guess it would be good evening to you folks over there in China. Thank you for inviting me. My presentation has to do with basically how to conduct an initial interview and subsequent interviews with your clients, especially where they are vulnerable. And I have provided a rather extensive PowerPoint presentation and some other handout material. And if you go to the second to the last slide in the presentation, it says that there are some examples that I will discuss. And so I thought to keep it a little bit more dynamic, I would go a little bit into the examples first and then go back to the presentation itself. So you can see how it all works together. Let me first start by telling you about some 30 years ago, I was in a place called New Orleans, Louisiana, and I happened to go into the criminal court there to see, to watch some proceedings. It's one of the things that I like to do. And on that particular afternoon, they were having initial appearances of accused. The accused were brought in their orange suits, and they were shackled, by a chain, and they were sort of all shimmying together. And what I noticed was the public defender or the legal aid lawyer having a conversation with the prosecutor, and then the legal aid lawyer going up to their clients and having a brief conversation. And when the proceeding was over, because at the time I was a public defender myself, a legal aid lawyer, I asked what exactly happened. And what I learned was the legal aid lawyer, who had just received the file, and maybe had spent 5 minutes looking at the particular file, was then approached by the prosecutor, where the prosecutor offered wanted to make a deal, and gave the defense lawyer approximately 5 minutes to accept it or reject it. In other words, what was being offered was only available for the next 5 minutes. And so the legal aid lawyer's job was to go up to the client, who she had never met before, and communicate that if he were to accept a 10 or 15-year sentence and not go to trial, that might be in his benefit, because if he went to trial or she went to trial, they may be getting a 20 or 25 or 30-year sentence or even more. And I thought about that. Now, how is it possible when you just meet someone and you're representing them on a very serious crime, and to approach them, introduce yourself, and within the next 5 minutes, tell them, without knowing anything about the case other than what you might have read, to say, here is a very good deal on the table that you should accept. And legal aid lawyers, at least in Louisiana at the time, were more than willing to pressurize their clients into accepting such deals, because they had so many cases. This is one way to get rid of a case. And approximately 95% of the cases get resolved, prior to trial. Only about 5%, I would say. And I would go so far as to say maybe 2% actually go to trial. The rest of them are at some point, negotiated away. And so when we talk about your initial appearance, your initial interview with your client, one of the things that I want you to walk away at the end of my presentation is a few things. First of all, you're dealing with an individual that you've just met. You don't know much about them, and you have a limited amount of time to get information from that individual, but also to give them information. Some of your clients are more challenging than others. Some of them have problems. Some of them come from a different culture. Some of them have mental problems. So there's no one formula as to how you would approach an initial interview, but there are some fundamental principles that you need to abide by. And let me just tick off a few things that I hope that you get out of this presentation, so that you know in the future how you might want to go about in structuring your interviews. The first is you need to adjust to the client's ability to understand. Your client is an individual. Who is this person? So you need to adjust to that person. You can't expect your client to adjust to you. You're educated, you're sophisticated, you come from a particular background. And so you can't expect the client to adjust to you. You need to adjust to the client. Limit your expectations. Figure out what you want to achieve from this particular interview. So limit that. Do not overwhelm the client with information. If the client is getting too much information, then they cannot understand exactly what it is that you're trying to convey. So you might want to limit that. Use simple language with the client, because if the client is unsophisticated, and obviously if you're there, especially as a legal aid lawyer, they're probably most likely are going to be unsophisticated. They need to be able to understand, and your job is to be a communicator. Give your client some time to give his or her story. That's an important aspect of it. In other words, you're there to learn as much as you're there to sort of teach or inform the client about the process. So when you ask a question of the client, actually listen, and you listen by actually making eye contact and by not interrupting. And listen very carefully if you can. Don't make any judgments. I can recall a client once telling me, when I asked him for the first time, what did he do? You know, he was this gentleman, he was in his mid-50s. He looked like he hadn't taken a bath in about 5 or 6 days. His hair was greasy, his clothes were disheveled. And when I asked him what he did, he told me that he was a nuclear scientist. Now, if you looked at him, you would say, no way, this person is definitely not a nuclear scientist. But he insisted. Of course, I made a value judgment at the time. I was a very young lawyer, thinking, okay, maybe he's mentally ill. Well, it turned out when we went into court and the judge asked him what he did, FBI agents stood up in court and asked that the client not reveal where he worked and what he did, because indeed he was a nuclear scientist and had been working at the nuclear nuclear facilities in New Mexico. So it's easy to sort of jump to a conclusion as to who you might be dealing with. And we'll talk a little bit more about that. So don't make any judgments about your client. Show some empathy. Try to establish some bond with your client, you know, as much as you can. And try to learn something about the client, because you might need to know more about the client in order to better understand where he or she is coming from. And then, of course, you want to make sure that at the end of your interview, you ask the client if there's anything that you can do for them. So basically, that's what I want you to get out of this entire presentation. Now, let me just talk a little bit about these examples, and then I'll try to weave them in as I go through the presentation. There are 4 examples, and by the way, I'm going to be with you tomorrow on a session, so we'll talk a little bit more about these examples in a different context, but I just want you to sort of get a flavor of the sort of challenges that you might meet when you're dealing with a client who's vulnerable, who you may not necessarily understand because they're coming from a different world, a different perspective, a different ethnic background, you know, and what have you. So the first one is, I was representing a gentleman up way north in Alaska, and he was, you would call them basically Eskimos, but he's an Inupiaq individual. native Alaskan, and he was accused of killing his father. Now, during the initial interview that I had, I went to see him. He looked at me for 30 minutes, never said a word, and went back into his cell. The next day, I went back and he did the same thing. Of course, I had introduced myself and I was waiting for a response. The third day, he came in, and after about 15 minutes, he said hello to me and asked a question or two. And that was the beginning of our relationship. Now, you might say, wait a minute, why would somebody come in after you introduce yourself as his or her lawyer and just stare at you for 30 minutes? And I mean, just literally look at you from eye to eye. He's just looking at you without even mentioning, without moving. He's just looking at you. And of course, I just sat there. I didn't ask a single question. I just introduced myself saying, I'm Michael Karnavas. I represent you. I'm here on behalf of the Alaska Public Defender Agency, and I'm here to help you. And so when you're ready to talk, I would like to get some information from you. And that was the extent. And I just waited. Now, what preceded this interview was the fact that I had learned, because I was new to that environment, I was just filling in that particular location as a legal aid lawyer. What I learned is that these particular Native Alaskans are different from other Alaskans, and they process information differently. Now, how did I learn this? Well, it was one of the first things that I did when I went up there is we had, the office had a local translator, and I used that translator as a cultural guide, as a cultural expert. I said, the very first day, I said, spend a day, talk to me about this culture. Tell me, how things are. Tell me how these people process information. And from hearing, my interpreter, I was able to find out some very valuable information, such as that these Native Alaskans tend to take their time when they process information. And, white people essentially get very nervous when they ask a question and somebody's looking at them in the eye and they're not getting an answer, so they begin talking. And she was explaining to me that the process is like this. That person is trying to figure out what you just said, and they're processing that information. And just about when they want to talk, you're interrupting their thought. And the communication between the two of you is, you're thinking this person is slow. On his or her part, they're thinking, won't this person shut up so I can talk or I can think? And there is this miscommunication. And so if you want to represent somebody of that particular Native group, you're going to have to be very, very patient. You're going to have to win their trust. You're going to have to wait until they're ready to speak with you. So in that instance, as I said, I just sat there, I waited. After 30 minutes, he just walked away without saying a word. But once he decided that he trusted me, and once he decided that it was time for him to speak, he spoke very slowly. And of course, I had also learned that because he had killed his uncle, who was, the son of his grandparents, that if the grandparents were to say, we forgive him, we want him home, that would take a big weight off his shoulders, and that might enable him to communicate. Because even though when you looked at him, he looked rather normal, he looked rather non-fazed by his environment or what was happening, he was actually suffering. But we didn't, you couldn't tell, because that's the way they react. So with that information, I was able to get a lot of information from the client, and we actually did a very good job for him because of that. And I credit a lot of that to my cultural expert, the translator. What's the point I also want to make is sometimes you don't have funds to hire a cultural anthropologist, but you can go to the library, you can pick up a book to tell you a little bit about the culture, about these people. You can use family members, or you can use an interpreter, the interpreter if you're using one, although you have to be rather careful to make sure that you're using the right interpreter and you're getting the right information. But there are ways for you to assist you in understanding your client, where they're coming from and how they process information, because that is going to allow you then to determine how much information you're going to give to the client initially and how you're going to approach him, and to what extent the client is going to be able to understand what it is that you're trying to convey. Because as I said, if you give too much information to the client initially, they may be overwhelmed. In fact, I would say most clients during the initial interview, a lot of the time, they're not even listening to you because of fear, because of anxiety. They hear perhaps half of what you're saying. Sometimes they hear what they want to hear, not exactly what you've said, which is why you may need to repeat something over and over and over again. The next example I wanted to discuss a little bit, and as I said, tomorrow we'll go into more details, is I was representing a gentleman, and he had gone in to a supermarket, and he was looking for medication, and he found the medication. It was just for a headache, so it was like aspirin, and he put it in his pocket. And when he went to pay for the other items that he was carrying in his hands, he was stopped for shoplifting, and he was embarrassed. In any event, he left, went home, and then came back and pretended that he had a gun in his pocket and he was going to rob the place. And what he wanted to do was he wanted the police to come so that he could show that if you really wanted to rob the place, this is how you rob it, not the way they're claiming that he took the aspirin and put it in his pocket. It's a rather bizarre episode. When you first hear it, you wonder, can anybody really say this and with a straight face? But he did appear to have some problems. You could tell just from talking to him. What I understood initially was that I don't know enough about this person. And so, and anytime you try to tell him that what he did was wrong, was not consistent with the law, he would get excited. And so it ended up that we needed to have him examined, and which we did, and we found out that he had this rare brain disease, which is why he did what he did. Now, had I not been, at the time I was rather experienced, so had I not been experienced, had I not been using medical experts in the past and what have you, I might have just, accepted the person's version and him being rather odd or coming up with a silly defense, because a lot of our clients will do that, ignore him, and he would have received a 10 or 15-year sentence, because even if you have your finger in your pocket and posing it as a gun, under the laws in Alaska, that's considered, like an armed robbery. So in any event, there is another example. During the initial interview, he's appearing to be odd. And so maybe you don't want to go so far as to irritate him, because then you may never be able to connect with him. Not jump into any conclusions, just take in his narrative. In other words, tell me what happened. Tell me why you did this. And just listen with empathy. And then try to figure out what you're going to do. And maybe that's not the time to explain to him what the law is, how the process works, but maybe just to let him know that there is this friendly voice, this friendly ear that is willing to listen to his story, because that's what he was trying to do. And then after that, figure it out. And after about 8 months of working with him, he ended up actually getting no sentence. What we did was make sure that he had the medical attention that was required for him. So another case is this Vietnamese case that I had. I used to do a lot of cross-cultural defenses. And there was this Vietnamese gentleman who came up from California, and he was a fisherman. He was a boat person who had left Vietnam and made it to the United States through refugee camps and what have you. And he was up there fishing with another Vietnamese fellow. They were working for Alaskan fishermen. They were very, very good. But his friend was also a very dangerous individual. And he, one night, hit him in the head with some object and then threatened to kill him the following day. And then the following day, my client was waiting for this other Vietnamese fellow. And when he saw him, he shot him 7 times in broad daylight in front of everyone. And in order to get to where this other person was, he had to walk by the police station. So for the average person there would think, well, obviously he was angry and that's why he killed. Well, that's one explanation. The other explanation, however, is when you go into the case a little bit more with your experts, is that this individual that we did a thorough background check on had a very violent past and had used weapons against people. And so my client, who knew that, had every reason to fear. And apparently, he really believed that when the person said, "We will kill you," that he would be killed. The reason he didn't go to the police station was because when he grew up in Vietnam, no one would dare go to the police and make a complaint, because a lot of times you would end up going to jail as opposed to them doing something that they're supposed to do, like investigate. So he had reasons to fear. Of course, we needed psychiatric tests. We needed to find specialists. And one of the things I'm going to talk about tomorrow is, in this particular case, Western psychology and the tests that they have are not necessarily applicable to Asians. And so to have your client administered certain tests that are not applicable to the way they think may not give you the right result. It turned out that we needed a specialist, and we were able to find someone. There was a place in Oregon that treats Southeast Asians. The doctor himself was Chinese Vietnamese, so he spoke Vietnamese as well. He understood the culture, and because he had been specifically trained, he was able to communicate to the jury, because we have a jury there, exactly how this person was thinking and what he was doing. More about that tomorrow, maybe. The last one is about a battered woman. Is a battered woman syndrome case. A woman put a knife in her husband's heart while he was passed out on the floor because he was drunk. He was passed out, from drinking, and she stabbed him. We argued self-defense, even though she could have walked out of the door. She could have gone to her neighbor. He was passed out. And we were able to get a successful not guilty verdict on self-defense. In other words, she was defending herself when she stabbed him in the heart. Now, it sounds a little ridiculous if you don't know about battered woman syndrome. It sounds even more ridiculous if you don't know the facts of her background. So getting her entire background was terribly important. However, because I had some experience with this, with battered woman syndrome, and also with post-traumatic stress disorder, which normally is associated with that, I knew that in the initial interview or 2 or 3 or 4, I would not be able to get all the information that was required of me. And why is that? Well, because a lot of it is personal. And so you're not going to get it all. You can only get a limited amount. And so the best approach is to understand that it's going to be a long process to get all this information. But as I said earlier, you don't want to judge your client from when you look at the facts initially, because it's easy to say, well, here you have somebody who is passed out on the floor, he's drunk, he's asleep, he's not doing anything, and to stab him, and then to say you stabbed him in self-defense because you were in fear of your life, and that you took the necessary measures, that the force that you applied was an appropriate force, and tried to convey that to 12 people for them to understand. And one of the things that we all need to understand, whether it's a judge or whether it's a jury, is that our clients live in a particular world that most judges or juries do not live in. Their experiences are different. And throughout the trial, one of the magical things about defending is to try to convince the judge or the jury to momentarily, 1 day, 2 days, 1 month, whatever, how long it takes, to suspend their notion of reality, of how things work in their house, of their experiences, and to enter your client's world, walk in his or her shoes, and try to understand things as your client was perceiving them, and then to judge them through your client's eyes and perception and what have you. And that's one of the things that you have to try to do. Otherwise, if you leave it up to the judge says, well, I wouldn't do that. I would have called the police. I would have done that, therefore. And then before you even begin to put on a defense, the judge has already made up his or her mind about your client. So anyways, those are the examples, and I wanted to raise those early on because sometimes we don't, when you want to cover a lot of stuff, you don't get to them. And I thought, why not go through the examples now? And then as I go through the slides, so we're going to go back to the second slide, preparing for the initial interview. One of the things I wanted to tell you is that an interview, whether your client is vulnerable or not vulnerable, 80%, I would say, is the same. 80%, 90% is basically the same principles. It's just that when you're dealing with a vulnerable person, you need to be extra careful. And sometimes you don't have enough information. So what you will be able to achieve might be very, very limited. But okay, so if you go through slide number 2, I talk about preparing for the initial interview. One of the things that you want to do is, depending on how much time you have, you want to get the information. You want to prepare yourself. So presumably you might have a file with some documents, the charging events, what happened, where it happened, to whom it happened, and what have you. You need to read that. Of course, there is a charge that says he's charged with this particular crime. That crime will, of course, have elements. What is it that the prosecutor has to prove in order to show that this person committed these events? A lot of times when I was a legal aid lawyer, when I get the file, the first thing I would do is make a copy of that page of the criminal code. So I would have it ready and I would have it in the file, and I'd have an extra one. So when I met with a client, I could show the client exactly what the charge is and what has to be proved. So I would have that. And of course, if there were defenses that went with that, I would have that as well. And one of the things I would want to do when I would go over the charges is to make sure that they understood the elements and the defenses. And I would want to do that before I heard the client's narrative. Now, why is that? Because I would want to make sure that the client fully understands what he or she is charged with. What are the facts? What are they claiming? What's in the file? That's number one. And of course, what does the law say? And what are the possible defenses? Now, the reason I would do that is because before I hear from the client's narrative, I want the client, if they're in a position to absorb all this information, to understand what he or she is facing. So I'm not there to say, well, tell me what happened, or you're charged with this, and then begin cross-examining or asking leading questions that suggest the answer, and as if I'm interrogating the client. That's not an interview. So once I look at the file, I try to have a game plan, meaning what exactly am I going to do in this particular interview? How much can I get out of it? So at that point, that's when you're going to more or less try to decide, to the best that you can, because you haven't met the client yet, is how much can I possibly get from this client? And then when you meet the client, then you have to be in the moment. In other words, you have your game plan, but you have to be flexible, because maybe on paper, your client appears one way, but then when you see him, because maybe he or she has been up for several hours and hasn't slept, maybe because of anxiety, whatever the case may be, you might be dealing with a wholly different person from the one that appears on paper. And so that's why you have to be in the moment, and you have to adjust. As I said, you have to make adjustments to your client. Your client is not going to make adjustments for you. So we go to the next slide. And so slide number 3, you want to introduce yourself. That's the first start. I like to introduce myself and tell the client a little bit about, who I am, how long I've been practicing. And I usually would start, right now I've been practicing for 40 years. And so I say, I've been practicing for 40 years. I do primarily criminal defense work. And I tell them a little bit about what sort of training I have. And I try to make eye contact, and I try to pay attention to what the client is saying. I'm trying to read what's in their mind. I was a legal aid lawyer, both at the federal level and at the state level, which means that the client has not selected me. The client's parents have not paid for me to go there. The system has. And unlike the system, say, in China, the legal aid system in the US is rather well known. It's rather established. It wasn't always the case. It's taken decades and decades to get to it. And then not every legal aid office is good. Some are better than others. Not every legal aid lawyer is very good. Some are way too overworked. And so they have lots of cases. But the thing is that you have to realize is that if you are a legal aid lawyer, if you've been, or you're the duty counsel, there is this trust issue. The client doesn't know, why are you there? Who are you? Who sent you there? And what have you? And, from my experience in working in Vietnam, it was always that the interest of the state came first and then the client. And now I was glad to hear, and which is the case, it should be the case, that you're there for the client. The client's interests are predominant. That's what you're there. You're there for the client. You're not there for yourself. You're not there for the state. You're there to protect the client. And your job as a lawyer is to provide the most meaningful information that you can to your client, so then the client can give you some instructions on what you can possibly or should, what you can do. And you can't do that if you have ulterior motives, if you're thinking about something else. So I would tell my client, I'm a public defender. The state is paying for my salary, but I'm independent from the prosecution, from the judges. So tell them a little bit about how the system works and what you're there for. Now, if I've had clients who have been in the system many, many times. And so when I would see them, they say, well, skip me the lecture. I know how it all works. Tell me what my case is about. Those are the easy clients. But most of my clients who are first-time offenders. They've never been in the system. They don't know how the system works. Maybe they know something about the system from watching television. Well, there's a big difference between television and reality. And also, if they're in custody, they're very, very anxious to get out or to have some kind of resolution as quickly as possible. So I walk them through the system. In other words, what's going to happen? Okay, you have these charges. The next thing, we're going to have an initial hearing. At this hearing, this is what's going to happen. And after that, and I walk them through the process so they have a full understanding and knowing also that I am not going to make any possible decisions on their behalf without their express knowledge, and authorization, because it's the client's case. It's the client's case. You're there for the client. So after you explain the process, then, and as I said, after you explain the charges and the defenses, depending on the time, maybe in the official initial interview, you don't have enough time. And normally, you may not. So, but if you have the time, then you might say to the client, okay, now what really happened? What happened? Just tell me. And just listen. Just listen to what the client has to say. You can always ask follow-up questions. Now, here's something that I want to talk about, and I want to stress. One of the things you need to understand is defense lawyers are looked upon rather differently than, say, the prosecution or the judges. The system, and when I say the system, and it doesn't matter where you are, it's been my experience. The defense lawyers are, they have this reputation in the community or among the police and the prosecution that somehow we are unethical, that our job is to represent criminals, that we identify with their whatever it is that they're accused, and that we try to get them off, to get them to free a criminal to be out there to commit other crimes. That's a perception. It's a wrong perception, in my opinion, which is why I stress that defense lawyers have to be extremely careful and extremely ethical. Careful because, you don't want to end up where your client is. And so you want to be as ethical as you possibly can be. So if we move to the one slide, and this is it, slide number 11, it talks about, this is Article 306 of China's criminal law. One of the things that I want to stress is that the information that you're getting from the source of the evidence, is coming from your client's memory. That's the source of the evidence. When you say what happened, and so it's the memory of your clients. Now, if you begin by giving information to the client, by way of asking questions that are leading, what you're doing is you're tampering with that evidence. You're tampering with the memory. And that can be very, very dangerous. Because if you ask, for instance, questions such as who, what, where, why, how, explain, describe, then you're going to get that information from your client. You can always ask a follow-up question, but they need to be open-ended. If you begin telling the client things that are unknown to the client, and then formulating the question in a way as to implant information into the client's mind so they can give you a desired answer. Then what you've done is you've tampered with that evidence. The evidence meaning, the source of the evidence. And you could very well end up being accused of trying to influence the client, influence the accused to provide false evidence. And I think that's what this Article 306 says. And by the way, it's not uncommon. That's something that's sort of you'll see in other jurisdictions, whether it's the Anglo-Saxon system or the civil law system that you have in other parts of the world. Basically, it's the principle is the same, that you should be very, very careful. And so this also applies when you're out there investigating. So it's not just when you're meeting with your client. When you are investigating, you're questioning witnesses, for instance, you have to be extremely careful not to provide information to the witness that he or she would not have had. And the reason that you're doing that, whether it's, whether you do it consciously or unconsciously, is to get a desired answer. Were you to do that, you obviously are tampering with the evidence, but also maybe the client has has information that is, if you get it untainted, if you're not tainting it, is going to be actually very helpful for you. So that's one of the things that I want to really, really stress, that in the process of getting your client's narrative, to be extremely cautious, not to inject anything during the interview. Manage your expectations. So we go to the next slide, slide 12. As I said, your client may be frightened, he may be angry, he may be confused. I've had situations where I can't even talk to the client because they're talking nonstop out of anxiety. And, you have to wonder, well, how am I going to help this person? They're not listening. And maybe if they're that anxious, because they might have, they're vulnerable in the sense that they have this, they're having an anxiety attack or what have you. It might be just that you just sit there and you just listen and just let them sort of wear themselves out a little bit and just talk about whatever it is that they need to talk, just so you can get them to the point where you can actually communicate and get whatever it is that you need to get from them. It all depends, in the situation. That's something that you need to do. When I was a young lawyer and I went to a training, they don't teach you this stuff in law school, by the way. It's everything that you learn, you're going to learn it through practice. Although there are, trial advocacy courses. I taught for 25 years at Cardozo Law School, trial advocacy, and I've taught elsewhere. And one of the things that we want to teach is client interview, the first client interview. And so I remember in one of, I was teaching at the National Criminal Defense College in Macon, Georgia. This is like a premier place for lawyers, not for law students. And we had actors playing the role of the client. So one actor comes in and we told him in advance to have a stuttering impediment to the point where it would take him almost a minute to get one word out. And there was a young lawyer, and he's trying to conduct this initial interview, and there's the actor witness who is trying to get the words out, but because of the stuttering, they're unable. And this went on for about a half an hour. And you could see in the lawyer's face that they were frustrated. They didn't know what to do. He didn't know what to do. He couldn't interrupt because it's not the fault of the client that he has a stuttering problem, but he didn't know whether he should just keep talking whether you tell the witness to just, the client to wait. But it was a valuable lesson in a sense that when you initially meet the client, because you don't know her or him, you have to make a quick judgment call. So one of the things that we would do in our office, for instance, in training young lawyers, is how to conduct an initial interview. And so that's one of the things that you could do. You could role play a little bit, or if you don't have that opportunity, to exchange ideas with your colleagues who may have been in a situation, and to ask them, okay, how did you handle that? To sort of exchange that information, knowing that you're going to be in the moment. You're gonna approach each client individually. There's no one size fits all. But having that information allows you, it's like a tool in a toolbox. You can use that tool or try to use that tool, or maybe you improvise. And that's what you need to do with your clients. Your expectations, as I said, you might have expectations to get somebody to agree to plead out. As I heard earlier, you get a benefit for pleading. Well, I would caution any lawyer. I don't care what the law says. I would caution you not to rush to pleading somebody out on your first initial interview. You can mention that there is this possibility, but it's too early in the process because you need to have enough information. The client may not know enough. You certainly don't know enough. And so if you want to do your client, if you want to service your client, and if you want to be ethical, you need to be able to give them the best possible advice. You can't give them advice if you don't know the facts, if you don't have enough. And so it might be that you need to go back to the prosecutor and say, well, there may be this possibility, but I need more information. You may need to do an investigation. You may need to have your client examined, because maybe, yes, you can agree that he takes responsibility, but there may be mitigating circumstances, sentencing. So it's not just, yes, he will agree to this, but maybe there's some other reason that you should even get a further departure from and lower the sentence. So I would hesitate to say, I would say, do not rush to get your client to agree to plead guilty to whatever the charges are, because most of the time, it's been my opinion, and I'm not naive at this point, most of our clients, most, not all, most, are guilty of one thing or another. Most of the time, however, I've noticed that the charges are higher than what they should be. Maybe because in the rush of charging, sometimes in the US they overcharge in order to have something to bargain. But whatever the case may be, let's not be naive. Our clients, most of the time, have done something. Maybe not what they're charged, but they have done something. Your job is to perhaps try to get as close as possible to what maybe really happened, and to lower either the charges convincingly so that the client can plead to what actually he or she did. But that's part of the process. And you won't know that until you get into the case. No guarantees. I have clients, that will select me. So I'm not a public defender. They will select me, but they say they want a guarantee. You need to guarantee me something. I want a guaranteed result. You cannot guarantee a result. So whether it's to the client or to the client's parents or whoever's paying you, if it's a paying client, you can never give a guarantee. You don't know what exactly the judge will do. And I think it's unethical to guarantee a particular result because you can't guarantee anything, and you shouldn't guarantee anything because anything can really happen. So be very, very careful. When you conclude the initial interview, I think always you want to say to the client, is there anything I can do for you? Why is that? Again, you're trying to build trust. It's about, especially if you are appointed, if the parents or the family members have paid for you, there's a little bit more trust because they think, well, we're paying for his services or her services, so probably, they're going to do a good job. But if you're a legal aid lawyer, they're thinking, well, the state is paying his salary or her salary. How can I trust this person? And especially if you think, based on your assessment of the evidence, that this is the kind of case that maybe the client should seriously consider pleading guilty, maybe to all the charges, some of the charges, lower charges, whatever. If that's the case, you're going to need to convince the client that it is in his or her best interest to do so. You can't do that unless there is some trust, unless there's some bond. And I'm a big believer in spending time with the client, although I understand that that's not always the case. You may not have enough time. You may only have 1 or 2 or 3 times to meet with the client. You may not have all the information when you initially meet the client. But if you have an opportunity to go back again and again and again, do so, because every time you meet the client, he or she sees that you care. And that's one of the things that you want to do. And I think it's very difficult, at least I've been for the last 40 years. And I always say that every client takes a little bit out of you. To be a real good criminal defense lawyer, you have to have empathy. You have to care about your fellow human being. If you want to make money, do commercial law. I mean, that's where you can make money. Commercial, corporate, find something else. But if you're going to be a criminal defense lawyer, you have to have passion for your client's cause. And what is your client's cause? Your client's cause is getting justice, making sure that he or she, if they are not guilty, that they don't serve time, that they're not falsely convicted. So you have to have that empathy. You have to show that empathy. And the only way to show it is by going and meeting with the client, especially if you want them to, for instance, plead guilty. You have to demonstrate to them that in your professional judgment, it is in his or her best interest. And you have to explain it to them. And sometimes it may take more than one time. But as I noted early on in one of the slides, you don't get a second chance to make a first impression. So if your first impression is bad, for whatever the reason may be, maybe you're overworked, maybe you're pressed for time, maybe it's a bad day, whatever the case may be, you've gotten off the wrong foot. And then, it becomes a little bit more difficult. So, if you only have 15 minutes with a client, because that's all there is available, tell the client, I only have 15 minutes. I apologize. This is how it is. Not that they're always going to understand, but at least try to let them know that, listen, I only have 15 minutes today. This is what we're going to try to accomplish today, and I'll be back. So you make a promise that you're going to be back, and then you keep that promise. And before you leave, you might say, is there anything I could do? Would you like me to pass on a message to your family? And then do that. Follow up. Show that you care. These little things add up at the end of the day. And besides, it's the right thing to do. It's the humane thing to do. As I said, you can't be a criminal defense lawyer unless you have empathy for people. And, we're not saying you don't have to identify with your clients, whatever he or she did, but it doesn't mean that they're not entitled to 100% of their fair trial rights, 100% of their constitutional rights. And that's important. It's important for all of us to understand that as defense lawyers, every client, no matter how guilty he or she may be, deserves the same kind of representation that we would want for ourselves. That's the important part. You're not there to judge your client. You're not there to say, well, he or she might have done it. Therefore, I'm not going to work as hard. You're not there to judge. You're there to provide a legal representation. And the way to do that is to get off on the right foot and to stay on the right foot. And you do that by constantly listening to your client and providing them with the best possible information. Now, for the special considerations, if we go to slide 13, I think it is, we start there. All right. Well, sometimes you're not aware of your client's special considerations. Sometimes you are. As I said, remember I gave you the thing about the nuclear scientist. He was a very difficult client. He was accused of kidnapping his son. He had gotten a divorce, and then he took his son. He had custody for a day, and then they ended up going to Nigeria, where he had a former student. My client, by the way, had 3 PhDs by the time he was 25. He was a genius. But he had other problems. He was unable to understand certain things, and the divorce obviously had caused him a great deal of anxiety and wasn't thinking very clearly. And it was very, very difficult to communicate with him. And it took some time to build the trust. So in that instance, I only had 5 minutes to meet the client and then go into court for the initial hearing. Afterwards, we had time. I spent a lot of time talking to him, figuring out, who he was, his background. But as I said, depending on the time that you have available and the information, a lot of times from what's in the file, even if you have 10 or 15 minutes, it might give you a lot of information. For instance, it shows that the client has been in a mental institution, or that a client has been diagnosed with a particular, disease or deformity or whatever. And so that might give you enough information. Or you meet the family members, and family members, you have to worry about mom telling you how great the child is, because no mom wants to say the wrong thing. But sometimes, they can be very, very helpful. You try to get them to say, okay, tell me a little bit about your son. And is there something that I need to know? And so you want to get as much as information. How vulnerable is that? But then again, I've represented a client, a young man, and the parents wanted to dictate how I should represent the son, and were demanding for me to provide them information with what I was learning from the son, my client. And I had to explain to them that even though they were paying me as the lawyer for the son, I represented the son. That was my interest. So just because the state pays your salary as a legal aid lawyer, you represent the client. You represent the accused. You're not there to represent whoever it is, whether it's the state or the local government that's paying your salary. They're completely independent. One has nothing to do with the other. But it doesn't mean that you shouldn't listen to them and try to get information from them that might be necessary and important for you to understand who it is that you're dealing with. Because again, as I said earlier, you have to figure out quickly during the initial interview, or even and then later on, how does your client process information? How quickly? How capable? Because then you need to adjust your message. You need to figure out, if I'm dealing, for instance, with somebody who's a very highly educated individual, and then they can read, they can understand, they have some worldly experiences, that's one thing. But if I'm dealing with somebody who's never been in the system, maybe they have some learning disabilities, and now I'm trying to communicate with them. How can I get the point across? I have to figure out, how do they process information? How can I make it clear to them what it is that they're charged with, how the system works, where do we go from here to there, and so on. And if you're dealing with somebody from a different culture, that's so important to understand the culture. So you need to talk to others who may not be as subjective, say, as the family members, but who understand a little bit about the culture. I usually try to read up and try to find out a bit about, the culture, the history, and what have you, because I want to know, and I'm naturally curious, but I also want to know, who am I dealing with? What are their experiences? As I said, I used to do a lot of cultural defenses because in Alaska, you had all sorts of people coming from all over the place. And it was important. One of the reasons it was important because I'm trying to convey to the jury, for instance, or to the judge, what's it like to be in this person's world? What's it like to be in his skin? And so, and as I told you earlier, one of the magical things about defending is to try to suspend, to get the judge or the jury to suspend their reality as they know it from their everyday, as a law-abiding, tax-paying, church-going, individual, to your client who may have had a very rough upbringing, who may be coming from a different culture, who process information differently. And so in order for you, judge or jury, to understand my client and to understand, what you should do with them, you need to understand their. So, for instance, just one example, very quickly, and I think we're running out of time.
Mr. Karnavas, yes, I think our time is over there.
Yeah, if I could give just one example,
Sure. Thank you.
And then, and I apologize if I've been talking too much for too fast, but this is one of my favorite topics, defending people. I was up in one area in Cambodia, and an individual had killed his neighbor, and he was a minority. And I was talking to the judge at the time. I was training judges there, and I asked the judge what happened. He says, "Well, he killed his neighbor in self-defense." I said, "Well, tell me a little bit about it." He said, "Well, this individual, his son died, suddenly, and he suspected that his neighbor had put a spell on the son, and that's why the son died. And he suspected that unless he killed his neighbor, the neighbor was likely to put a spell on his other son and maybe his wife and what have you. So he killed out of self-defense." Now, and I asked the judge, I said, "Well, how did you handle that?" He said, "Well, I gave him a relatively light sentence." I said, "Well, how did you figure the sentence?" And he said, "Well, I applied the law 40% and I applied his culture 60%. Of course, we had to explain some things to the gentleman, but there is a good indication where a judge, and this judge was very unsophisticated. He had not gone, he was barely trained, but he had enough sense because he was from that area and he understood. And here's a good situation where he's dealing with a vulnerable person, and in dealing with that person, he took into consideration the cultural background and what have you, because, and he actually believed that, yes, he killed in order to save his family. Now, if the person had lived in, say, Phnom Penh, the capital of Cambodia, maybe the judge would not believe him because, but being in that area, because Ratanakiri, and being that kind of a minority, and the fact that they believe in these sorts of things, that made it much more credible. Anyway, I hope this presentation was informative. And if you have any questions, I'll be more than happy to answer.